Good afternoon, everyone. I'm pleased to be chairing the next session of the day, the individual insolvency, the case for a single gateway, with Professor Peter Walton. Just by way of introduction, and for myself as chair, I'm Christina Kicks, and from Interpath Advisory. I'm an insolvency practitioner, and my practice is 50% personal, complex matters, and 50% corporate, so I cover the full range. So we're joined by Professor Walton, which is great. So he's taught at the University of Wolverhampton for 30 years, widely published work, and has been cited in the court in home and abroad as well, including the UK Supreme Court. So he's completed various research projects, including those for the UK government and the UK insolvency trade and professional bodies. So I'm very pleased now to hand over to Professor Walton for his presentation.
Thank you very much. Hello, everybody. Thank you very much for returning from your coffee break, and hello to everybody watching at home or in the office. I'm thrilled to be here, and I must thank the Insolvency Service for giving me the opportunity to talk about personal insolvency, which I don't normally get to talk about. So I'm very pleased to be given the opportunity, and thanks to my former colleague, Chris Umfreville, at Aston University for helping to arrange the day. So what I'm going to talk about today is just individual insolvency, personal insolvency, and I'm going to look at certain aspects of the current regime and then look at some history to see if all of that points a way forward, which might suggest that a single gateway is the future. It's a sort of slight single issue fanatic stuff in terms of looking at the history for some signposts. So I'll look a bit at the current regime, concentrating really on the IVA scheme and how the IVAs are working at the moment, and from that sort of identifying potential weaknesses in the current system that may or may not be capable of being remedied by looking back to go forward, and in terms of looking at a possible single gateway. So that's what I'm going to have a go at. I'll be happy to take questions at the end. I should say before I start that the remit of today was to think outside the box and to think sort of revolutionary. So if you don't like my thoughts, I'm just doing what I was told, and I'm happy to change my views if it offends anybody. I'm probably not. So the current system, is it working well? Well, who knows, I suppose. But it seems to be functioning fairly robustly across the board. So we've got bankruptcy based upon creditors' petitions. Not much has changed in that area for quite a long time, and that seems to chug along without too much criticism. We've obviously got bankruptcy based upon the debtor's own application, which, when it was introduced, obviously created a bit of a furore, and lots of people thought that was a sort of the beginning of the end. And I'm not sure that's really been the case, and that the adjudicator, a public official, makes the order rather than a judge making the order. So I'm unaware of any major criticism of that system, so that seems to be okay. The debt relief order seems to have been a huge success, and you've got here the official receiver acting both administratively and judicially, and the numbers for DROs are very healthy and suggest that there was a real need for such a provision, so that seems to be going okay. I've said the breathing space regulations, is it too early to tell? It probably isn't that early to tell, because they seem to be pretty popular. There's sort of about 5,000 a month according to the latest stats. So there's obviously a real hunger for such a provision. So they seem to be going well. And then we've got IVAs. Are they working well? And it's really IVAs I'm going to talk a little bit about at the beginning of my talk. So the reason why IVAs are so important is that they comprise about 70% of total individual insolvencies. So that was certainly the case in 2020, not quite so many in 2019, but the way things are going in 2021, it seems to be at least 70%, if not more. Certainly the figures that came out earlier this week for September suggest that IVAs there's over 7,000 IVAs in September, just 614 bankruptcy orders and just over 2,000 DROs. So again, we're looking at over 70% of individual insolvencies being IVAs. So they're a big part of our personal insolvency landscape. So So how do they work? Well, just for the, for the sort of uninitiated, I've sort of relied upon the Paymex HMRC case because that's a sort of good starting place. And essentially, when we're talking about IVAs, the principal activities carried out by the insolvency practitioner involved at the nominee stage will be negotiation and payment handling subsequently once they're a supervisor. So at the nominee stage, the IP acts as an intermediary between the debtor and the creditors, and it's usual for the nominee to draft the IVA proposal, or have a big hand in drafting the IVA proposal. The nominee then reports to the court as to whether or not the IVA proposal is a winner, whether it's a realistic option, and if the report's positive, then the nominee will proceed to convene a creditor's qualifying decision to vote on that proposal. So one of the things which is really obvious about IVAs, it's obviously obvious about CVAs as well, is that you've got an insolvency practitioner who normally drafts a proposal, then reports on that proposal, and is often the person that's appointed as supervisor of the subsequent IVA if it's approved. And so there's some issues around whether or not there's a need for any independent person to have a look at any of that, apart from just the creditors getting full disclosure and for the creditors to vote on it. So I'm not suggesting there's a problem with what IVAs, nominees are doing there. The statute says that's what they've got to do, so they do it. But there's no independent assessment of that beyond the creditors giving full disclosure of the details of the proposal and then voting on it. It doesn't go to a court, it doesn't go to any other independent person. So that's one of the themes of what I'm going to try and talk about. Obviously, it was a bit different before 2003, when you couldn't have an IVA without first also having an interim order. So it was assumed that you'd always want an interim order, this idea that you would have a moratorium on actions against the debtor whilst the proposal was being considered by the creditors. And one case, Re Judio Sullivan from 2001, is an interesting case where the court looked at a proposal in considering whether or not to make the interim order, and the court said lots of things about how the court would look at a proposal. And they said the proposal should be one which had a real prospect of being implemented. The court should look to see that the IVA offers a reasonable prospect of a better recovery for the creditors than in a bankruptcy. But interestingly, on the facts, the court refused to make the interim order because the size of the nominee's fee was considered too high. And so the court made quite a few sort of comments in the case about how the court has an unlimited discretion, but obviously has to exercise that discretion in a judicial manner in whether or not to make the interim order. And one of the other things that the court said, which I thought was quite interesting, was the court noted that creditors, especially small creditors, would take comfort in having the court allow the IVA to proceed with the terms and remuneration levels agreed between the nominee and the debtor. And so the point is, with the court's involvement before 2003, creditors could have some comfort that someone's looked at the proposal and thought it was an okay proposal. There was nothing sort of obviously terrible about it. And so there was some independent assessment of the proposal before it moved on to be considered by the creditors. Some other sort of background bits and pieces in terms of how IVAs work. You're probably aware of all of these things, but just to sort of remind ourselves, we've had standard terms and conditions that R3 drafted, I think back in 2002, so way before our time, Caroline. They have been updated, that's true. And they've been copied as well by the CVA standard terms, not quite copied, but used as inspiration for the standard CVA terms, the COVID CVA terms. So we've got standard terms and conditions from R3 which are widely used in practice. As you probably know, most IVAs, although IVAs were intended initially following Cork to be directed towards people in the professions or company directors, in reality most IVAs tend to be consumer IVAs, and so since I think 2008 we've had a consumer IVA protocol which again has been updated. And I guess the big thing in recent years has been the creation of these volume providers of IVAs, and that's really one of the things which I'm going to talk a little bit about in a second. And so the Insolvency Service has provided guidelines for how the professional body should go about monitoring volume IVA providers. And the IPA's volume provider regulation scheme is such a thing, and so it's a system of continuous monitoring of those volume providers. So that's quite an interesting scheme, and the reports are very detailed, and I'll talk about some of the points made in those reports in a second. In addition to that, we've got proposed amendments to SIP 3.1 in the offing, and there the sort of main headline there, I guess, is that there are concerns around how debt packages are being used by certain volume providers in terms of how work is being brought in and how those debt packages are being paid for that work, and whether or not the pre-insolvency advice being given to debtors is appropriate for the nominee to then move on and consider an IVA. And so we've got all those things going on, and obviously we've had this week an announcement by the Financial Conduct Authority that it's proposing to ban these debt packages being paid a referral fee for pushing work on to nominees. So it's a sort of moving feast, if you like. So just in terms of what the sort of problems are, what perceived problems are in the area at the moment, is it all around volume providers? Well, certainly that's where most of the sort of noise is. What does volume mean in this context? Well, if you control more than 2% of the IVA market, which is around about 5,000 IVAs, if you've got around about 5,000 IVAs that you're supervising, then you would be a volume provider. So that's what the scheme applies to. And in terms of the IPA's regulation of that and oversight of it, the most recent benchmark report was in March of this year, and it followed on fairly swiftly from an FCA report, the Woolard Review, which looked at many aspects of the unsecured credit market, but had some interesting things to say about the IVA market. So I'll move on to that. So what did the Woolard Review say? Well, it said that there were concerns around the functioning of the IVA market, which is not regulated directly by the FCA. So the FCA is saying, well, it's not really our fault if there's anything wrong there, not regulated by us directly, we're sort of involved, but not really. Quite damningly, they said the often high and front-loaded fees for these solutions were driving poor outcomes and practices for both consumers and creditors. The message from these respondents, including both consumer advocates and creditors, was clear: the IVA market is broken. So that's not a very positive message. And the sort of stuff they were talking about there was that there were high levels of commission being paid to these debt packages, these people that were getting referral fees, sometimes over £1,000 per referral, and that's driven potentially harmful business models. That's, I guess, the catalyst for the FCA's announcement this week. In terms of what the IPA sort of said about all of that, well, they've looked at the market for these volume providers more generally. So just by way of background, so you don't have to read their latest report, here are some interesting bits and pieces. So this scheme that's designed to oversee volume providers, it covers 68% of all IVAs. So it's a fairly significant scheme in terms of the regulation of IVAs. And according to the latest report, that's over 200,000 of the nearly 300,000 active cases. And there are currently, at the time of the report, there were only 7 scheme members. So you've got 7 organisations, 7 companies running over 200,000 IVAs between them, which is an interesting observation to make. And it's not quite clear from the report, but it seems to suggest that the 7 scheme members between them only seem to have 18 IPs that are supervising all of these IVAs, with the help of a number of staff, obviously, and lots of sort of electronic tools to make the system work well. But it is quite interesting that such a small number of IPs are supervising such a large number of IVAs. I guess that's the point that I'm trying to highlight. One of the points that the IPA make in their report is that the IVA market has now found a solution to the criticism of the FCA report in terms of the historical fee issues. So there's some positive regulatory action there. And obviously the draft SIP 3.1 is tightening the regulation of reliance on these lead generators and these debt packages in terms of the IP needing to be aware of what advice has been given to the debtor before the IVA is moved on. One or two other bits and pieces by way of background, again from the IPA latest report. In terms of the volume providers, in terms of the IVAs that were commenced, I've just picked a year at random in 2017, so there were nearly 60,000 IVAs commenced in 2017 by these volume providers. As at the end of 2020, 3,839 had been completed. There were still 38,674 that were ongoing, and 16,500 had been terminated early. And so it's quite an interesting statistic, and arguably a bit sort of largely consistent with the sort of CVA rates that Sue was talking about in our first session. So they're not always successful by any means, but there is a reasonable success rate, and even the ones that are terminated, or if they're still ongoing now, they're likely to be leading to some payment to creditors, one assumes, than if the IVA hadn't happened. So there is potentially benefit to these things. One of the other bits of information I thought was interesting is that there are still 17,000 IVAs open that are over 6 years old, and that number's down from 27,000 the previous year. So there's some work going on in terms of limiting these IVAs dragging on forever, as it were, and a lot of those involve the realisation of equity in homes, and so it's perhaps understandable that they go on a bit longer. They tend to go on for about 5 years, as you probably know, but there are obviously quite a few still kicking around after 6 years. The IPA is sort of very confident that its continuous regulation of these volume providers is making a difference, and that it will deliver lasting confidence in the market. So I think to be balanced, to keep that in mind, that they're making great efforts to improve the regulation of the volume providers. Some other bits and pieces from the IPA report. A majority of debtors were making payments of £100 or less, monthly payments of £100 or less. There was a sample of IVAs which suggested that approximately 25% of debtors were in receipt of some form of benefits, and so that might surprise people that if you're on benefits, such a large proportion would still be seen to be the right people for entering into an IVA. In terms of the volume providers themselves, there were 7 of them listed as at August 2020. One had ceased to take new appointments during the year, with its IVAs transferred to another provider who then joined the scheme and subsequently rebranded. In August 2020 also, another member ceased to trade, with its IVAs transferred to a connected party who entered into a service agreement with a Mauritius company connected to another member. So it's a strange looking market to an outsider. I'm not really commenting on any of that, but it's a small number of people, a small number of organisations controlling an awful lot of IVAs. And so that in itself is interesting. Yes, I won't say anything further, I'll get myself into trouble. In terms of other comments the IPO have made, we remain concerned over the ability of an FCA-regulated entity to have numerous appointed representatives who can advertise and give advice without the same level of scrutiny as members of the scheme. So we had our FCA report a few minutes ago saying, well, it's not, these people aren't really regulated by the FCA, it's somebody else's problem. And now you've got the IPA saying, well, it's not really, we're a bit worried about these FCA-regulated people doing various things. So it's quite an interesting attempt to sidestep some of those issues. I'm probably quoting out of context, and I don't want to be too harsh to the two. I'm really making the point that this market is a funny market in that you've got a number of professional bodies involved. And it's not quite clear who has responsibility for all levels of scrutiny. There's also, as you probably know, been some problems around some questionable advertising of IVAs. You've only got to spend the day at home watching daytime TV to have all sorts of things offered to you, and sometimes you get offered quite an interesting deal for an IVA. Unethical advertising has been highlighted by some unlicensed lead generators found by the ASA. So there's a number of people looking at this market, and there are some issues that could be improved. The IPA is committed to tackling iniquities in the volume IVA market, but has to work within the existing regulatory confines while still seeking to achieve significant regulatory impact. The IPA considers that more change is needed in the volume space. The IPA's view is that the IVA market has outgrown legislation which was designed for a different era. I'll come back to that point in a minute, but essentially what the IPA is saying, which seems quite reasonable, is that we've got this sort of volume providers of IVAs, but the IVA wasn't really ever intended to be used in that way, and therefore the legislation's out of date. Maybe the legislation needs to be updated rather than anything else. So, in terms of a sort of brief summary of what we've got there, it seems that we've got a relatively small number of IPs advising on and supervising a huge number of IVAs. Who is actually making the decisions? Is it the IPs themselves? Is it their staff? Or is it these lead generators? Or is it a mixture of all of those people? Who's responsible for regulating these things? Is it the IPA, is it the FCA or the ASA, or is it a mixture of them? And are the problems that might be perceived by the current system a problem of regulation, or is it there's a fundamental problem with IVAs or a fundamental problem with the legislation? So that's what I'm going to move on to consider next. And one of the patterns that you notice if you look at the history of insolvency law, certainly bankruptcy law, is the way in which official involvement sort of comes in and goes out of trend. So quite often you've got some government action, and we've got to take control of this. We need officials to take control. Only official involvement will sort out particular problems. At other times, governments are saying, well, there's too much official involvement. It's the creditors whose interests are at stake here, so it's up to the creditors. The creditors can vote on whatever they like, and the creditors should have the final say. But the question really that I'm posing for myself, I suppose, today is it time to consider more official involvement in the context of personal insolvency, based upon some of the issues which I've inadequately explained in regard to the IVA market. So we could consider the history of bankruptcy law. Can we learn anything from that? I thought I'd run through a very short history of officialism in personal insolvency law. So short history lesson, nothing too grotesque. There's a picture of Elizabeth I. 1570 wasn't our first bankruptcy statute, but it was sort of quite a significant one in that it was the first time we had bankruptcy commissioners appointed. They were appointed by the Lord Chancellor, and their activities were partly judicial, partly administrative in terms of how they were dealing with bankruptcy. So that's 1570. I'm going to jump on to an anagram of 1570 to 1705. That isn't Queen Anne. That's Daniel Defoe, who was a bankrupt himself and campaigned for a change in the law on bankruptcy. And so partly due to his campaigning, we had the introduction of discharge from bankruptcy in 1705. But for our purposes, more interestingly, in 1705, we had the introduction of these people called assignees in bankruptcy. And the idea of this assignee in bankruptcy is very similar to our trustee in bankruptcy now. So they would take possession of all the bankrupt's assets and could sort of enforce rights on behalf of the estate, realise the assets, and move on from there to hopefully distribute money to the creditors. And the idea of this obviously is that it's really the creditors' interests that are at stake in a bankruptcy, so the creditors ought to be able to appoint their own assignee in bankruptcy to look after their interests. And after a while, not surprisingly, although it seemed like a good idea at the time, various fraudulent practices grew up, and it became apparent that these assignees in bankruptcies could not always be relied upon to act honestly and not commit various sort of frauds. So then we sort of leap on to 1831. That is William IV. And we have our introduction of officialism, or sort of reintroduction of officialism. And we've got this rather interesting sort of hybrid type of person. There's two people, so it's not really a hybrid, it's a dual appointment. So in addition to an assignee being appointed by the creditors, we also have an official assignee. And the idea was that the official assignee would sort of keep a track of what the creditor's assignee was doing, and so there was a sort of break on the potential sort of fraudulent activity. In reality, the official assignee seems to have had the whip hand and had most of the power in terms of realising the estate and acting on behalf of the creditors. it seemed to work quite well. It was very popular apparently for a while, but as with all these things, it sort of didn't stand the test of time ultimately. And the official assignee was paid usually by way of a percentage of the realised assets, but that led to huge payments being taken by some. So they changed the system so that they would just be paid a sort of fee for each bankruptcy, which meant they couldn't really be bothered to do the job terribly well. And so that led to a considerable amount of negligence and indifference in the collection and distribution of the estate. So we had that. So official assignees were sort of popular for a bit, but didn't really continue with that popularity. And then in order to sort of deal with that, we'd get rid of them. So in the 1869 Bankruptcy Act, we just got rid of the official assignee altogether. So we abolished the role of official assignee, and we returned to a form of trustee in bankruptcy appointed by the creditors. So that was our Bankruptcy 1869 Act. The problem with that is the sort of same old problems that we had before reappeared, and there was great delay and expense experienced in the administration of bankruptcy estates with the near total irresponsibility of the trustees. Returning to voluntarism didn't seem to do the trick either. So we've had officialism, that didn't quite work, it didn't stand the test of time. Go back to the creditors having the decision as to who should be in charge of the estate. That doesn't seem to be working either. And then we have the 1883 Bankruptcy Act, and if you want a problem sorted out, you want a guy that looks like this guy, because he's all business. So this is Joseph Chamberlain, in case you don't know who it is. So he was the president of the Board of Trade at the time, and Chamberlain's solution to this was to introduce what we now have, the Official Receiver's Office. And the idea behind this was that we need some sort of independent person who can have oversight of the bankruptcy process, who isn't going to be subject to sort of potential fraudulent activities and isn't going to be completely controlled by the creditors either. And so that was sort of a major point in our history. Just very briefly, in terms of the bankruptcy procedure under the 1883 Act, just in very outline terms, upon proof of insolvency, the court made what was called a receiving order. Many of you probably will remember receiving orders from the pre-1985 law. The official receiver would act as a receiver of the debtor's estate upon the making of a receiving order. This preliminary stage might or might not ripen into a bankruptcy. The debtor's creditors might agree to a scheme of arrangement or composition of debts, but if this was not possible, the next stage would be for the court to adjudicate the debtor bankrupt. So the receiving order was a sort of staging post, as it were. So as soon as insolvency is proven, you have the receiving order. There's a moratorium on actions against the debtor during this period of time. Most receiving orders did lead to an adjudication order, did lead to bankruptcy, but it was possible during this interim period for, well, initially the creditors, but subsequently the debtor to put forward some sort of composition or scheme of arrangement to convince the creditors that the debtor shouldn't be made bankrupt and instead should be allowed to push forward with this scheme or this composition. So the function of the official receiver, according to Chamberlain, when he was talking in the House of Commons on the Bankruptcy Act, was that there should be, in every case, a public inquiry into the circumstances leading to the insolvency. There must be a public official to conduct this inquiry. In order to ensure the official behaves responsibly, he must be under the direction of a Department of State, which is responsible to public opinion and Parliament. So any official receivers in the room, that's your origin. And Chamberlain emphasised the collection and distribution of the assets of the estate were primarily the duty of the creditors, but that official interference, our officialism, was limited to the supervision which was necessary for the protection of a minority of creditors and to ensure honest dealing by all those involved. So that's our sort of background. And as we know, we went sort of 100 years almost without too much change happening to our bankruptcy law. And then we've got the Court Committee, and Kenneth Cork, the picture of Kenneth Cork. And the Court Committee wasn't sort of too impressed with the way in which the law had developed with regard to the receiving order, in that in the Court Committee report, they noted that there'd only been 26 compositions or schemes in the previous 10 years. So as a way for a debtor to deal with his or her debts, it wasn't sort of crash hot. It wasn't really terribly successful. As we know, the court committee recommended the IVA, but the IVA was really recommended just for professional people or for directors of companies who were trying to avoid insolvency. And in fact, the court committee recommended a form of single gateway and recommended a thing called a debt arrangement order, which would be court-led, which wasn't taken up by the government of the time because it was sort of too complicated, amongst other things. But we've got the IVA, and as I mentioned before, the IVA was initially linked to the need for an interim order. So at least initially there was always some court consideration of an IVA proposal because you had to get an interim order, so you had to come to court with your proposal and the court would opine on whether or not the proposal was realistic or not. I mentioned the O'Sullivan case earlier on. There's another case that's sort of similar, sort of entertaining read, Davidson and Stanley, where the court said the proposal was an essay in make-believe, which was a sign that that wasn't going to get terribly far. So the white paper was that led to the Insolvency Act was in favour of the IVA, but it's interesting, if you read the white paper, the government of the time did refer to a desire to reduce official involvement, and there was a comment that IVAs would make binding these private arrangements without unnecessary official involvement. So we're not quite going back to sort of 1869, but essentially the policy of the day was, well, it's the creditors who will make a decision, it's up to them how they do it. But there was this link to the interim order, so there was some official involvement in the decision for an IVA to go forward. Coming back to where I started, I'm just going to go around in circles. The IPA report from this year, the IPA is campaigning for an audit of the commercial landscape, blah, blah, and a review of debt management products in their entirety, the IVA in particular. So they're keen for the IVA to be looked at. Interestingly, on their website, it calls an IVA a formal court-approved agreement. Which was news to me, but what I'm suggesting here is there's a sort of a hint at a potential solution there, that maybe we do need some official involvement in the approval of IVAs. One of the issues that we haven't really talked about, and I'm not really going to go into in any detail, is that whether or not there are issues with regard to confidence in the independence of the IP, sort of hinted at earlier on. If you've got an IP who's drafting a proposal, reporting on the proposal and then acting as supervisor, there is a suspicion that they might not always be as independent as they might be. And certainly when I did some work on CVAs recently, talking to various stakeholders in the context of CVAs, there was a suspicion from a number of creditor groups and other interested stakeholders that IPs weren't always as independent as they might be when they were pushing a voluntary arrangement to creditors. So, with all that in mind, is lack of officialism the problem? So the 1883 Act introduced a scheme which permitted effective debt compromises to be agreed by the debtors, but also ensured there was some official objective initial assessment of such compromises. If you like looking at ancient forms, you can have a look at that. The 1883 Act provided for a single gateway into individual debt relief, and what I'm sort of heading towards now, I will stop talking in a minute, is maybe it's time for a simplified version of this. Maybe that would work today to deal with the problems of the current volume IVAs. And there are sort of other precedents kicking around. I was really interested in, Stephen Baster wrote a really interesting piece with John Tribe on the debt provisions during the two world wars. And the stuff in the World War, some of the stuff that was in World War II, where you had an adjustment officer who was involved in the promulgation and approval of a compromise or scheme of arrangement for a debtor affected by the war. That seems to be something which we haven't really considered, and certainly the authors of that article suggest it's something that we ought to sort of factor in when we're considering looking at improving our current system. So the system, is a single gateway a good idea? Well, to some extent, in my mind, I'm still not 100% convinced, but I'm sort of steering towards it. The system for individual debt relief needs to be simple and accessible. I think most of us would agree with that. So if we have a proposed single gateway, I've given it a really dull name, the individual debtor gateway. It's almost impossible to come up with a duller name than that, so apologies for that. But I've gone for INDEG. At the time it sounded all right when I was sitting on my own, but it's just a dull acronym. So we would have a two-stage process, and there are obviously immediate issues with a two-stage process, I agree. So whenever there's a voluntary proposal for either bankruptcy, a DRO, or an IVA, that proposal would first need to be considered by a public official in the INDEG. Even where a creditor's petition is successful in court, the debtor would still enter the INDEG, because that's where all our public officials would be working. On entering the gateway, the debtor would have the benefit of a moratorium, so sort of similar to an interim order or breathing space regulations, or what the court committee were talking about. They were talking about something that they labelled a protection order, something along those lines. The public official would initially consider the most appropriate next step. So they would consider whether, for instance, if there's a proposed IVA, whether or not that's appropriate and whether that particular IVA is appropriate. So whether there's a prima facie case that the proposal for the IVA should be put to the creditors or not. If the proposal passes that test, it proceeds to a creditor's decision at that point. The official may decide that a different route is to be followed, for example, that a DRO or a bankruptcy order is a better option for the debtor than the proposed IVA, in which case the gateway would act as an independent assessor for the protection of the debtor, minority creditors, and ensure honest dealing by all those involved. If the application, whatever it is, isn't supported, it may ask for more information, suggest amendments, or refer the matter to maybe an independent party with appeal to the court, or have an immediate appeal to the court. Obviously, there are various sort of ancillary issues that one would need to consider. So in my mind, the system would build upon the current structures that we have in place. So people like the bankruptcy adjudicator and the work that the OR does with DROs, they would be subsumed within the gateway. And so one public official, one type of public official would deal with the order-making function that's currently spread out there. And the role of the official receiver would go back to what it used to be always, the sort of in terms of the investigation and estate administration, but within the context of the gateway organisation. That's it. Thank you for your attention, those of you who gave me your attention. And thank you.
Thank you. That was really interesting. And we've got a number of questions coming through from those watching online. And so if anyone in the room as well would like to raise a question, there's 2 hands up. Just while you're passing the microphone, I might just raise one question that's come here, and just starting with IVAs, because that was the beginning, obviously, of your presentation, is how can the Insolvency Service tackle the mis-selling of IVAs when there's such profits in those companies that are involved? And I'd probably extend to that as well. You were mentioning the FCA regulations. How can the non-payment of referral fees be policed?
I mean, I deliberately didn't get too far involved in those issues, because I realise that's a hornet's nest that I don't really need to be stung by. So it's really a question for other people. But I would have thought if you were really unhappy with the way that market is developed, you could stop it. And one of the things which is crucial to an IP is that all of their appointments are personal appointments, and so you could toughen the rules on how an IP is allowed to supervise literally thousands and thousands of IVAs. That seems inconsistent with the basic idea of how an IP is licensed and why IPs came into being in the first place. So I think there's some work you could do around that if you wanted to. In terms of the problems around sort of debt packaging and sort of the referrals coming from various people. That is a difficult one, because obviously it's regulated at the moment, but if you then sort of ban it all, which the FCA is suggesting, then you run the risk of having an unregulated type of behind-the-scenes referral system. So you could, I guess, ban it by doing that. And that would certainly stop regulated people doing it, but whether or not it would solve the problem entirely, I guess it wouldn't.
Yeah, no, so it did, yes. So I think really by the insolvency practitioners, regulators themselves could be a way, is what your suggestion, which makes sense. So I think question from Caroline over there.
Thank you, Peter. You've focused very much today on volume IVAs, and I know why, because that's the majority of them. I think I would really agree with your comment that IVAs in the volume sector are really not what was intended when the legislation was written. But I really want to make sure that we don't lose sight of those IVAs that are still done by IPs on an individual basis, often for very complex personal financial situations to deal with. And I'm really worried that unless we actually acknowledge that those IVAs still exist, there is a really good reason for doing them, that we lose the ability to be able to do that when we're looking at changes to the IVA world. And my next point is that the DI rates are really interesting. I think 10 years ago, you'd look at an IVA and probably the average monthly payment was £300. And now you were saying in your paper that it's less than £100 a month. And I think then those sort of disposable income levels really make the individual very susceptible to a change in their personal circumstances, which means that they lead to a very high failure rate. But also it means that actually the available money within the IVA itself for the IP is very, very low. So that must inevitably lead to economies of scale, very little personal involvement in each case. And that potentially is an issue in itself. So forget people coming in, actually is the IVA suitable for somebody with £70 a month disposable income? And that's something that I think could be validly looked at. And I think I share your concerns as well about if you ban all of the debt packages, then where do individuals go for debt advice? Because if there is no money to be made from giving somebody advice and being able to package that information up, where do you go to for debt advice? We already know that the debt advice charities are really underfunded. They can't cope with the levels of demand that they've got now. And I would say that one of the things that we do need to look at is the current IP exemption. So if an IP is FCA authorised, they can give debt advice over the full range of products. If they're not, they can only give advice on in contemplation of an insolvency appointment. And it just seems an absurd distinction to make when an IP can be appointed a trustee in bankruptcy, but they're not allowed to advise an individual on that debt option. So I think aligned to this, that's something that I'd like to have looked at in the future.
Yeah, anything else, Caroline?
No, I'll stop now.
I tried to make a note of all your points, but I've got an insolvency service pen that just didn't really want to work. So I'll do my. I know it's working now. Obviously, now that I don't need it so much. I think with regard to debt advice, I think you're absolutely right. That's a huge problem which I deliberately haven't sort of gone near to today. And the way in which the proposals to change the way in which face-to-face debt advice is available to people seems a really bad step that's being brought in. And one way of helping to resolve that is absolutely right, to get IPs. You know, IPs are really keen, aren't they? A lot of IPs are keen to do sort of pro bono, give advice to people, but obviously a concern that they're breaching their professional practice rules by doing that. And that seems like an untapped well that one could easily see lead to real positive benefits for debtors. So I 100% agree with you. I think in terms of the sort of the sort of traditional IVA, and I've spoken to lots of IPs that do the sort of full-blown IVA as it was more intended, I guess. And certainly I wouldn't suggest that my sort of new structure, as it were, would have any impact upon that, because those things would be largely sort of waved through by the public official, as long as it's a sort of genuine IVA proposal, which it would be in the context that you're describing. I don't think there would be any problem with that. It's just about the bureaucracy in terms of any sort of delay, I guess, would be the issue with that. And I think one of the problems with the sort of low payment IVAs is what I agree with what you I'm going to agree with what you're saying. Is IVAs, you know, different governments have tried different things with IVAs in terms of sort of simple IVA, in terms of the fast track IVA, and none of those things have really sort of moved anything on. And then, you know, we had the Tribunal Courts and Enforcement Act 2007 in trying to introduce new options, and you know, apart from the DRO, none of those were really well, none of those have been brought into force. And so I think there is a space. It might be something similar to what the court committee actually recommended back in '82. There is a space that's designed for consumer debtors, which isn't a full-blown IVA, but it's something else, and it might be court-led, it might be led by a government official. But I think there is an argument that I mean, one of the things we were talking about this morning is there are too many options, and there is a danger of having too many options. But is the IVA the right option in that context, or could it be made into the right option? I guess is a significant point. So I haven't got an answer to that.
Thank you. And I think we've got a question at the back there.
Thank you. Fascinating paper. I have two questions. One is technical and one is policy-based, taking account a wider range of market considerations. So the first is, if you had your official gateway, in how far would that limit debtor choice? So if somebody said, I still want to go for an IVA, but it's not the most reasonable option according to the adjudicator, would the debtor still be allowed to choose an IVA? What would you think? And the second thing is, something which has come across to me over the years is that many debtors, for one reason or another, are greatly afraid of entering into official state-governed debt procedures, often irrationally. So if we foreclose the possibility of a free market IVA, and there's hundreds of good reasons for that, but would the effect be that debtors would wander off into non-official procedures like debt management plans or potentially the new statutory debt repayment scheme? So would we achieve the opposite of what we would like to achieve?
Thank you for your questions. So in answer to your first question, you would obviously need to have built into the system some form of appeal system. So if you think you've got a really sensible proposal for an IVA, if the gateway says you've got to show a prima facie case that's likely to be effective and likely to be considered positively by the creditors, if that's your yardstick, then it would only be a very poor one that wouldn't sort of pass that test, and obviously you would need some form of appeal to an independent body, probably the court, if you were sort of given the red light rather than the green light. So I take your point. You're going to need to have some sort of appeal system. In terms of the second point, it's a tricky one, I think, and you're absolutely right. There will be debtors that don't want to go near any official thing. And at the same time, a lot of the misadvertising of certain debt repayment policy sort of products tend to say, oh, it's a government-approved thing. It's all you can rely on us. It's the government that's right behind it. So that obviously has some attraction for some people. So I don't really have an answer. That's obviously it is a policy issue, and we don't want to sort of drive people to loan sharks more than they already are going to them. So I don't have an answer to that, I'm afraid.
Walton, and there's caused lots of debate, your presentation, with lots of questions, but unfortunately we have to wrap it up there due to time. So yes, thank you all for joining, and thank you, Professor.